Good afternoon. It is really a pleasure for the Embassy of Mexico to the Netherlands to have this meeting of the Club de Droit International holding an online and presential session at our premises in The Hague. And we have the honor of welcoming Alejandro Celorio, who is Mexico's legal advisor at the Ministry of Foreign Affairs. And Alejandro is a colleague from the Mexican Foreign Service, someone who I consider myself a friend, someone with whom I've had the honor to working together in previous positions in the Mexican Foreign Service. And he is a very distinguished lawyer. He is one of the torchbearers of this well-recognized Mexican tradition of international jurists. He studied law. He obtained his law degree from Universidad La Salle in Mexico City, and then joined the Mexican Foreign Service and got the opportunity of having two graduate courses within the Foreign Service itself, one in the University of Houston on U.S. domestic law, which for us is key, and a subsequent graduate degree on international law from the University of San Francisco. So Alejandro has been designated legal counselor from almost from the beginning of the current administration in Mexico. And with that, let him speak for himself and share with us some of the main topics that Mexico promotes within international law and within our interest in multilateralism. So I will leave Lester and Alejandro with you, and I will take my seat in the audience.
Thank you very much, Ambassador. Welcome all. Thank you, first of all, to Ambassador Celorio for receiving us in this, which is your house, in such an occasion. To have your head of legal advisor for the Minister of Foreign Affairs. An impressive CV. You've mentioned it, so I'm not going to go into that, but we wanted to highlight that these are high times for multilateralism, particularly within the neighborhood that our two countries are placed geographically. And hearing it from the head of your legal services in the Ministry of Foreign Affairs is an unparalleled opportunity for us to understand the challenges and the opportunities ahead. I don't want to take more time because everyone is expecting you to speak, not me. So please, without further ado, leave the floor to you.
Wonderful. Thank you very much. Good day to all of you. Really appreciate this invitation by the Club de Droit International. Thank you to the Embassy of Mexico in the Netherlands. It's such an occasion. My first time in The Hague, and I couldn't ask for a better weather for all of you that are here in The Hague. I have the impression that this is the common weather. I believe it's not so. So thank you very much. I'm very excited to be here, and I'm going to start with a common place that for all of you, I'm sure you hear it and you believe it. Why is it important in international law, and why multilateralism is so important right now? We face challenging demands, and I believe they're not as different, perhaps different circumstances, but just as challenging as they were 75 years ago when the UN Charter was signed. But the fact of the matter is that international law and multilateralism has allowed states to have some level of certainty of what the word of a state means in terms of international obligations, and how the rule of law will allow to have certain structure in the world to solve peacefully the difference between states. So it is undeniable that international law and multilateralism are the foundation stone, the cornerstone for a peaceful life in the world, and regular relations between states. As I talk about international law from the Mexican perspective and multilateralism from the perspective of international law, I will highlight the key topics that we're working on now in the Legal Advisor's Office. I want to salute my colleagues in Mexico City. I will refer to a lot of the work that they do on a daily basis. And as we all know, international law is not a matter of a single person. It is a matter of inheriting the knowledge and the willingness of people to do better things and build upon the work of others. Why is multilateralism and international law so important for us? Our neighborhood is a challenging neighborhood where we live. And international law has allowed us to sit at the table in the same level of sitting. And multilateralism has allowed us to advance issues and circumstances that perhaps on a bilateral setting would be hard. International law has put Mexico in a position of great tradition. We all know the Treaty for Non-Proliferation, with great lawyers in the Mexican Foreign Service, and the diplomatic service. And we continue with that tradition, encouraging and leading some efforts in the multilateral arena. Some examples: we are actively participating in the drafting and the discussion of the potential treaty of biodiversity between national jurisdictions, PBNJ. I have to share some personal experience. That was my first time in the UN, and my first opportunity to be involved in a multilateral setting. And we take for granted the language in a treaty. We believe that it's just good wording that is then translated to the official languages of the UN. But we seldomly think how difficult it is to draft and get to the language that it is signed at the end. And I want to share with you the leadership of Mexico in multilateral affairs by resorting in international law with the thought of, it's not the language, it's the framing of an international obligation between states. And some of us could ask, why is Mexico so interested in certain topics, like coding of drafting of a mining code under the International Seabed Authority? It is important because we believe in the rule of law, and we believe in have certainty and have some regulations of how states will interact in the future. Either is in the mining of seabed resources, in environmental agreements, in the promotion of international humanitarian law, engagements, and eventually, if there's some discussions about the space law and how there's going to be mining in farther planets, I'm sure Mexico is going to be involved. And this is because we believe that it's important to hold the states' commitments in international law, and not only in the treaty, in implementation, but actually hold the states accountable for what their word means. Somebody is signatory to a treaty. That means that regardless of the political party that is ruling certain state, that commitment is of the state, and it has. And that's the beauty of international law and multilateralism. It is a contract of the state with another state, and Mexico is a firm believer of that. That's why we always try to engage and have an active role in pursuing the drafting of multilateral agreements and the respect to international. And I go back to the idea of international law and multilateralism as a technical matter away from political interests. In the 2 days that I spent here in The Hague, it's been so interesting to recognize that there's a political intent in certain decisions. But when it hits the rule of law or the legal institutions, the political intent is put in place. It's, in a way, it is constrained by the international law commitments. And that gives us some tranquility and some certainty that regardless of the political intentions, there is a legal framework out there that gives certainty to our people, not only to the ministries or to the legal advisors, but to our people, that there's some sense in how the states will relate. I got a number of meetings today, and one of the most important meetings that we hold was with the prosecutor and the International Criminal Court. I expressed Mexico's support on the court, and I was reading this morning the Rome statute and how forward-looking was the drafting of that treaty and how important it is. And perhaps it addresses challenges of 20 years ago, but it will also address the challenges that we'll face in 20 to 30 years. Mexico is a firm believer now, and it was before, that it is important to hold accountable those committing the most heinous crime under international law. And that as state parties, as the leaders in the world of law, we need to support the court needs. I went also to meet in the International Court of Justice. And as I was entering the peace palace, I was thinking of the Avena case that you've heard of. Mexico was under the belief that the Vienna Convention of Consular Relations was and has and will have to be respected. And when 51 Mexican nationals weren't granted the right to receive consular assistance in the United States, we brought the United States before the accident. And we got a positive resolution. But what happens now is that that decision by the ICJ hasn't been able to be implemented in the United States, because there's a lack of understanding of the extent of international law and our commitments in international law. And one of the objectives of Mexico, that's again how I stress our intention to promote international law and multilateral fora, is that our word should mean something as states. And when we sign an agreement, when we sign a multilateral treaty, that means that we want to uphold our obligations. I talk about the Vienna Convention on Diplomatic and Consular Relations. One of the challenges that we're facing now is the development of the discussion about privileges and immunities. As contracting parties of the Vienna Conventions, we need to uphold our responsibilities to provide privileges and immunities. But there are certain commercial relations that will develop in perhaps labor issues and labor sentences. So the topic of immunity of jurisdiction and immunity of execution is an active topic. Perhaps if we have time to discuss, I would be very interested in hearing everybody's opinion of how what was thought before perhaps has to be analyzed and discussed now, but is still within the realms of multilateralism and analyzing if the immunities of jurisdiction and immunities of execution have to be thought and discussed under the new realities of more intense commercial relations in international organizations. Other areas where we are involved in terms of multilateralism and international law is the defense of cultural property. As you know, other countries with a broad and depth tradition and number of cultural properties and inheritance of ancient cultures, we face the challenge of recovering and protecting our cultural property. Mexico is going to join UNIDROIT and ICAO. It's already part of UNESCO Senate. And we'll keep pushing for more multilateral efforts to protect and give a chance to those countries of origin to protect and recover their cultural property. I mentioned also international humanitarian law and how important it is for Mexico, even though we're a country with no armed conflicts. But we do believe in the promotion and the learning of international humanitarian and how we need to set certain rules for the engagement and during armed conflicts. We actively participate in the promotion of international humanitarian law. Other areas where we have been involved and is worth discussing it is in the efforts to, without being a full treaty, more of a political declaration of the protection of refugees and migrants. As a country of origin, transit, and return, we signed a law compact on migration and refugee in Marrakesh. And we hope that in the near future that could develop and evolve in a binding agreement. It's one of the most challenging topics, but the most pressing is to set certain set of rules to protect and provide some framework to face the challenge of migration flows. The administration of President López Obrador is fully engaged in multilateralism and the respect of international law with a feminist perspective. I want to mention the need of more women in the decision-making structure of international law. We need also to keep in mind the gender needs, the diversity needs when drafting multilateral agreements. The respect of international law is at the end what we have to keep it, to be in the table at the same stature than other states and try to arrange and to find peaceful solutions for any controversies that we might find. Mexico just finalized the new trade agreement with the United States and Canada. And even though it's not specifically for the legal advisors and the Ministry of Foreign Affairs, it's not its responsibility, we are involved in the dispute resolution mechanism. And the USMCA might be the best example of how an agreement under international law, a mechanism under international law, will balance the table and will allow Mexico in this specific case to better protect the rights of migrant workers in the United States. In the previous agreement, NAFTA, the USMCA's predecessor, the mechanism to solve disputes regarding labor weren't that clear. It was very burdensome and very difficult to bring a case and solve it. But now in the new treaty, I believe it's going to be easier to find the right way to advance some claims to the United States and Canada for not fulfilling their obligation under international. What other challenges we're facing and opportunities we're facing? Very real, very down to earth. Some of us still believe that international law is a number of good wishes and good willing and perhaps good wordings, but they go down to actual issues that have to be solved. Mexico is facing some situation in our northern border related to water. And it's interesting the interaction between local authorities and federal authorities and the decision to uphold our legal obligation in a bilateral treaty with the United States. And I want to stop here to reflect for a moment on how, among colleagues, on how we might think that international law and multilateralism is out there. And so often people, a layperson, in their regular activities, don't know to what extent international law impacts and how the state they live in, country they live in, might be bound by international law by treaties. So there's a principle that resonates continuously in my daily work. We cannot claim domestic law to stop fulfilling an international obligation. And that, I believe, that is the key of our times. Even though more and more countries are looking inward into their national interest, we do not stop being in a world with obligations, where there's already a framework of international law, where obligations do not disappear just because we want to look inward. We need to continue moving forward. We need to continue strengthening the international law framework and resorting on multilateralism to find solutions not for today, not for the juncture problem or the current context. We need to look into the future. And talking about the current context, Mexico is actively participating in the multilateral effort to find a vaccine for COVID-19. As you all know, there was a resolution sponsored by Mexico to, under the United Nations, to grant full access and universal access for the vaccine. It has been a learning experience on how those with more resources might have the ability to get vaccines faster, and how multilateralism, and again, being on the same level table, all countries might be, and hopefully will be, able to access the vaccines based on multilateral efforts. And there's an international law component. Of course, if you want to access certain amount of vaccines, but then you have bilateral agreements here and there, there's some binding language in the multilateral effort where it binds you to really uphold this obligation to allow universal access to the vaccine. It doesn't mean that you go and you talk in the multilateral arena and say, we will participate in this, but behind that effort, you start buying vaccines everywhere. You buy vaccines everywhere, that means that from this multilateral effort, you will get less. So everybody gets the same amount of vaccines. Certainly, the discussion around the access of vaccine resumes and encompasses what I think is now the perspective of Mexico about multilateralism from the angle of international law. It's not only good wishes, happy language, and good intentions. It's a commitment to participate and to look into others, and from the regional and the global sphere, and say, we're going to commit to this and we're going to hold our commitment so everybody can get a vaccine. I believe we face a lot of challenges based on the attacks on the international law system. I believe it's easy to look inward and say, I don't care what happens in the rest of the world. It might be easy to deny that there's the other outlet. But what is undeniable is that there are commitments under international law. And that multilateralism will allow to keep this evenly set table where every country will have to conduct under the rule of law, under international law, and the multilateralism will allow us to keep advancing. Thank you.
An extremely engaging presentation. Very, I would say, all-encompassing. You touch almost every possible field of international law and multilateralism. But I'm very sure that our audience has many questions for you, and I would like to use my position at the table and start with one question. And without pushing you to say something you, of course, cannot, I would like to know from your position, what has been the attitude of your office facing the position of not only retreat from multilateralism, but blatant attacks to multilateral engagement in the different arenas that you mentioned. You visited the I'm very sure that you are quite aware of other instances where these things are happening in nations, access to the vaccine, whether you lecture, trade, etc. So being in Mexico, a galvanizing presence in international affairs, I'd like to know what is the position of your office in this.
Now more than ever, I think we cannot, in my office, we cannot be naive and disregard the political situation. So as much as we would like to present arguments based on international law, there's also political elements that we cannot disregard. But in that sense, what is that we have to do, and we will do it here at the as legal advisors? We need to find the right law, the right language to uphold international law. I'll put an example. There's a border wall between Mexico and the United States. Of course, as legal advisor, I would like to complain about that horrific and isolating infrastructure in front of between my eyesight and the United States. Am I going to complain as legal advisor on a Twitter saying that's a horrible border wall? Perhaps what I should say is that infrastructure perhaps might cause damage to the environment, to this obligation. So with that example, I'll bring it back to the ICC. I can personally to express support to Prosecutor Droit. Prepare the staff, the court, and the court. And then we'll engage bilaterally with those actors that need a reminder that for the court to fulfill its mandate, it needs the support of all the states, parties, and non-parties. So at the end, it's not a political approach, but it's a very, I would say, a strategic approach of using international law for a political message. It is as hard as answering
Yeah. So, should we open the floor for questions? APIs? Let me bring another question up too. You've mentioned several times language, but let me talk about languages. Being a part of the multilateral engagements, I've seen how our own language, and I apologize to the Spanish-speaking audience, but I will use that example as personal experience. We've seen how our own language has increased in importance more and more in multilateral affairs, and it's the fate of most of the other languages besides English in multilateralism. There's always an excuse, lack of interpreters, this is just a nestless group, we don't need interpretation, common language, lingua franca, whatever. So what can we do to protect and enhance the presence of the other 5 languages of the UN system with this almost hegemonical position of English?
Thank you for your question. I think it's language we don't see it as a vehicle of engagement with regional partners. I'll go back to BDN. There's an effort called CLAM, Latin America. We advance with positions is a regional group. The beauty of that group is that we have so many synonyms, and synonyms are so important in drafting agreement, because that's when you can unlock the discussion by finding the right synonym. And I think we should see more Spanish-speaking countries working in advancing perhaps certain positions, and also presenting Spanish as a convenient tool, not only because of the number of people in countries speaking Spanish, but of the bias, of course, the beautiful of language, and the number of how malleable it is to find that right language. We could have the counter argument that English, or certainly other official languages, is more technical, but perhaps it's easier. To the point, even in the drafting of a document, the structure in English allows shorter, whereas our Spanish is very flowered, and 2-line paragraph will become a 6-line paragraph. That's not good for an agreement. But we should be proud of our language, and we should keep pushing for the opportunity to draft. Perhaps the working document should be in Spanish and then translated with another language. I'm sorry, completely biased.
I think that the Droit should think about organizing an event in Spanish too. Huh? We already have one in French and several in English, so we will consider that as well. There's a question from the floor.
Very much. So thank you for being here and thank you for inviting us. Now, my question is more about the regional cooperation framework. We spent a lot of time on this. And if you could just elaborate a little bit how you see them as one of your tools for multilateralism for Mexico. Perhaps you get a bit of emphasis on the American court on human rights, how you see the potential for developing of jurisprudence, and how it is reflected in the work of the Mexican tribunals. How they take it into account.
Thank you for the opportunity of answering that. Certainly, the inter-American system will actively participate. I would say that somehow is newer, so it's in the making, and it's for Mexican courts to absorb it and start shaping the decision based on the decisions by the inter-American human rights court. The importance of the system as a regional system, I believe, is that because it's a regional club in a sense, so we'll feel more comfortable because it's someone we understand each other better, culturally, in the language. So I think there's a lot of potential in the system to keep advancing. And to advance in its own jurisprudence, following in a bit what Europe is doing. Perhaps not to the extent and not in the depth of the European Union, but the inter-American system presents a good opportunity to advance certain understanding of the law. We just had an interesting exchange with our colleagues from Bolivia regarding asylum law. That is a tradition, a more regional tradition in America. What is asylum? Who can grant asylum? When a state is obliged to offer a safe conduct. Very interesting, and it gave us the opportunity to see how particular we are as a region, all of us with a civil code, a civil law tradition, and the extent of the opportunity to develop our own jurisprudence. Now, I believe for the inter-American system to keep on growing, we need the political support of the system, the Organization of American States. And again, looking forward, looking outward, looking for the regional to advance in a common, or at least close to common understanding of the law, instead of looking inward and trying to continue promoting insights between the different understandings of the law.
Ask a question.
I think I left too much time for questions.
No, not at all. You will respond to the question.
Well, maybe I don't know if you can, if the people in the region could listen to the audience. But having been with Alejandro to his own schedule in The Hague, which I think is the world capital of international law, I think maybe you can elaborate a little bit more on two other areas, because you focused on public international law, but what about private international law and arbitration, which are also one of the two main international law areas that we have here in the
Thank you for that.
What is our perspective as Mexicans in that?
Certainly. And so often we live, and pardon for doing it here in this presentation, so often we live private international law because it's not public. So it's not in the news. I was mentioned in one of our meetings. But it's so important, and today conference I was discussing that how real and tangible the results of the application of the convention and child adoption programs or the protection children, or how direct impact that has on individuals. And it's something negotiated by states. Mexico is an active participant in these conventions, and there's a clear reality that we face. For example, in the Hague Convention of Child, we have around 11 million Mexicans in the United States. And a good number of them are mixed marriages. At least half of them, 4 point something million, have an irregular immigration condition, which means they are under the threat of deportation back to Mexico. Mexico is also a country of transit of migration flows. And if people are in a regular manner, they might be subject to repatriation. But the children often remain behind. And moreover, if they are born in the country of destination. And the Hague Convention on Child Support presents such an opportunity for state parties to have a real impact and facilitate the protection of children in terms of providing needs. Right? The protection of cultural property, again, as I was mentioning, Mexico wants to join UNIDROIT 95 on the protection, prevention of illicit traffic of cultural property. Private international law, I think, has been left unnoticed, but it keeps advancing, and very effective. Mentioning it, very discreet and effective. And the same happens with arbitration. But if I may engage out of the topic of conversation of multilateralism, but going back to international, arbitration has, in my view, and after all the engagement, good opportunity to offer a different and perhaps faster venue. But the question is arbitration, international arbitration, impacting the credibility of national courts, the development of our own national judiciary? Is there a competition between arbitration, which is often very expensive and is not accessible to everyone, or is complementary to national courts? And in particular, I'm going back to the fact of labor disputes with embassies and international organizations. Usually, immunity of jurisdiction is granted in the post-country agreement if there is a mechanism to solve these labor disputes. But what happens when you have a local employee that doesn't have the means to travel to New York or hire an attorney to participate in arbitration? It is there. Go back to good faith, goodwill, nice language in the post-country agreement. But effectively, perhaps that person has been denied access to this. So I'm leaving The Hague in terms of arbitration with more questions than answers of where we are, and I would really enjoy engaging with you in that discussion. Because it seems that it's not for everybody. Arbitration should be complementary. But I fear that the more arbitration is used by private actors, the less workforce will be advancing, and their credibility perhaps will just remain. I see this is not stop at
The questions as well in terms of state policy regarding what is arbitrary and what's not, right? So the state can still exercise some sort of tutelage over those rights that the state considers that it should protect. I think that there's a question in the back with a Mexican diplomat.
Thank you, Lester. I think you just touched upon something really, really important, and I would also like to ask about that it's a real, practical, everyday effects we get to see of international law and multilateralism in everybody's life, in everyday life. And I think for the regular citizen, multilateralism, international public law is something ethereal that happens somewhere in the world and doesn't really necessarily apply to their life. This is something like legal advisors, diplomats, do in this luxury or luxurious environment, and they don't really have any application. So, and we know it's not the case. So, as legal practitioners, as diplomats, it's our responsibility to let people know how real implications of international law and multilateralism are in their life. But what would be your advice as legal advisor to actually get that message through and let the regular citizen know that what you are doing in the Ministry of Foreign Affairs, what we are doing here in The Hague, has a real impact in their life regarding child protection, or if they're even coming in a country, or I don't know, in every aspect of what we discussed today.
Thank you very much for that question. I believe that even though we are biased as international lawyers and we will promote and advance international law, we need to see it as one more tool in our toolbox for the everyday person. They must see international law and ways out there as something that imposes an obligation to the state they live in. Sometimes it imposes an obligation to them in terms of human rights and also rights. But we need to better present international law as a complement, additional to what is developing in domestic law. And the way we present it is the level of success we'll have when people understand it what is international law. Because I do agree, and I still believe it's international law sometimes is up there. But at the time of a negotiation, some people will think that it's just the law of certain country that has to be applied. But when you bring back principles of international law, some interpretations, and you make reference to certain cases, is the way we present international. One thing I forget to mention of our efforts, and this goes to the core of international, how we look at international law, is the traffic of weapons from the U.S. to Mexico. And we've been working around. We're still analyzing how we're going to get it. But when we look at international law, we don't look at it as we're going to find the statute in that shelf of that office where it says this is the relation we have to do. No, by reading the cases, we might be able to imagine different strategies of how we can do things. How can we approach the cases? And this is among international lawyers and foreign practitioners. For the day-to-day person, they should see international law as a means to advance in their rights, a way of setting some sort of relations and framework, and just have a better living. Going back to the vaccines, the way we present universal access to vaccines is not that they're going to be available in every single corner, but perhaps when we say every country will have their fair share, people take it. For the day-to-day person, that's easier to understand international law and multilateralism than saying after exhausting conversations we were able to get these declarations. You and someone from Zimbabwe and someone from South Africa and someone from China will be able to have the whole vaccine as a result of multilateralism and international.
Can I follow up on this
Please.
vaccine situation? And I thought the Mexican Revolution was really wonderful, and this call for accelerated scientific cooperation. What makes you think that the situation with vaccines will be different from how access and benefit sharing with regard to BBNJ? And that's the main issue. You have two groups. One that cares about marine conservation and preservation, and then the group that cares about access and benefit sharing. Why will this be any different or easier or in order to be able to have this universal access?
Good question. Complex in the sense that they have some similarities, but at the end, vaccine, we're talking about human rights.
But they both have pharmaceuticals involved.
Oh, yeah.
And we know how they are.
Certainly. But let me put it this way, without being in an official position and in the confidence of this room and the virtual universe. we can live without BBNJ. We can continue discussing. And I'm sure we're going to go to a FIFA and so on. We cannot continue without this. So I believe that the purpose of that resolution is to call out everybody. This is real, and we have continued. And if we think about the virus as pollution, it's talking about international environmental law, the pollution coming from upstream to downstream, it will affect the downstream. If the virus is not stopped in all the regions, in all the world, it's going to eventually pollute everybody. So it's in the benefit of everybody to understand this. Now, the private sector and pharmaceuticals, we're going to need more than multilateralism and international to try to come to some sense of what is happening. But I believe the stakes are so high, it's life or death, that I do believe we're going to advance this. And perhaps this is a showing, an opportunity to say, if we can advance in this vaccine, why not we can advance in BBNG, another multilateral? Because now is the vaccine, but tomorrow is going to be the pollution of the oceans or the melting of the ice caps. There are life or death decisions that have to be tackled on the multilateralism and even international. I'm going to take that back, that vaccine BBNJ, to the Mexican delegation and see if they can make the parts.
Thank you very much for the presentation. I have two unrelated questions. One concerns actually vaccine. I understand that Mexico, I know that this is private sector, but signed an agreement with Oxford, and the vaccine didn't continue to the first stage, to reach the second stage and it was stopped. And my question is, I don't know if you're aware, you know that if Mexico is going to continue its commitment for its agreement with Oxford, or if it will also going to find out if it's possible to reach an agreement also with Russia, China, or the United States that also in the production of the vaccine. That's the first question. And the second concern the refugees, you mentioned before. I learned from someone in this room that the border for Mexico is the most expensive border in the world. And I understand that, of course, there is the law available, but I don't know if the recent pandemic situation has raised the need to create new mechanisms, regional mechanisms, to actually to try to find better solutions for the situation of the refugee at the moment.
Thank you. Without knowing the details of the agreements around vaccines, I would put it this way: it's an assumed risk and joint risk endeavor. I think all countries, we could have waited for the pharmaceuticals to run and the universities and the investigation centers to run the risk and see if the product works. And when we have the vaccine data, we can go buy it. I believe it's worth commending all the efforts of saying, let's work in parallel. And if it works, great. We're working in parallel, we'll make the vaccine, the production will be distributed. And we can advance those steps in parallel instead of waiting for the vaccine to be available. If it doesn't work, I think it's worth a risk. And there's not only public sector involved in Mexico, there's also private sector that is interested in investing. Perhaps it's a business decision. But at the end of the day, hopefully we'll have a vaccine that passes phase 3 and is ready for production and distribution. And countries like Mexico and other countries will be ready to distribute and help everybody get it. It's a life or death that I think is demanded assuming those risks. And on refugee, that's my background. I spent almost 10 years working on migration in the United States. I didn't mention it in my presentation, but I do believe that in multilateralism and international law, as much as it's a diplomatic language, we also need to have an adult and sometimes difficult conversation about it. The issue of migration flows and how we better respond to the needs of migrants also demands a difficult and very arid conversation about migration. That's a reality. What is happening right now is that Mexico continues being a country of transit and destination for a lot of migrants. But there's also the will, and I would do it if I had my family in the United States, of transiting to the United States and attempt to enter irregular. And under the pandemic, the United States nowadays has put in place this rule that under health conditions, they can have an expedited expulsion to their country of origin. What are the arguments? And I cannot talk for the United States, but what I heard from them is the more time I have them here in detention, in the absence of availability of testing for COVID, the risk is higher. So I'd rather return them to their home country. But what happens to the home country, it says, and it's happening in some countries and in other places in the world, why are you returning me people that are infected? So it has been a very difficult conversation about, it almost seems that the person is contaminated and nobody wants to help if I may use that guy. But yeah, I don't want it. It's infected, came infected. When it got infected, she crossed the desert in the United States. Sadly, the conversation is not around how can we help infected people. It's about how can we contain the contamination and the transmission of the infection. If we could have better immigration control actions throughout the region and throughout the world, perhaps we wouldn't see people venturing to travel from Congo all the way in the United States. And in addition to having a serious conversation about immigration controls, we need to have a serious conversation under international law about international protection. If a person is escaping persecution or they fear for their lives, they shouldn't be venturing all the way to Alaska and transit to the country. There should be a way of finding. That's a pending matter that I do believe, again, under multilateralism and Marrakesh and the Global Compact, attempted to engage, but it was so difficult to find consensus, and some countries didn't want to be a part of it, that it just stayed as a political declaration, non-binding declaration, where it had all the need to become a binding agreement, so we can end with the dying of refugees in the border in the Mediterranean and trying to find a better life for escape persecution. But it is, I think, it's a pending matter how we are responding to the pandemic and the refugee crisis.
No? Thank you. I would like to follow up on Eduardo's question about migration, because there is also and thank you again for your excellent and very instructive talk. There is also a policy that was being implemented by the United States in cooperation with Mexico before the pandemic in relation to migration at the border. And that is the so-called MPP, Migrant Protection Protocols, and famously known as the Remain in Mexico program, whereby there is an expulsion, systematic expulsion of migrants from seeking asylum and refugee in the U.S. across the border to Mexico, where they are due to await their hearings in the United States in order to obtain the requested refugee status. So how is Mexico dealing with that challenge in a very different environment and context now, especially since a lot of very serious commentators have criticized the MPPs, not only academics, but practitioners, and in private, I do know quite a few members of the ranks of international organizations who also not really look very favorably on this practice. So how has this evolved in the current challenge? Of
course. The so-called MPP, it stands for Migration Protection or something. Going back to language, if you read the declaration by the Department of Homeland Security, it almost makes sense. You want to request asylum in the U.S., so you have two options. You can be in detention in the U.S., or you can wait in Mexico, free of detention. So it would be better if you would say, well, detention centers in the US are detention centers. It's not an happy place. So for a person to say, oh, I'm willingly going to wait for my asylum claim to be processed in Mexico, where I don't fear persecution, I'm not going to be tortured, I won't be deported, I'll stay. Around 65,000 people have been returned according to the DHS numbers. What is the position of Mexico? If an individual wants to seek asylum, refugio, refugee, Mexico, that's how we call it, they can do it in Mexico. If they want to request it in the United States, they're free to do it. If they want to wait in Mexico, they can wait in Mexico. They won't be arrested or deported. That is the frame of the situation. If we move the country upside down, and people wanted to request asylum in Guatemala, it would be the same. We want to stay in Chiapas or requesting asylum in Guatemala. That's okay. And it's not that they're waiting in Mexico in big halls just for the audience. They're free to move and go back and forth. There are complexities. It is difficult. But people want to request asylum in the United States, even though the rate of acceptance is very low. What is happening nowadays with the pandemic? And this is the real challenge that has to be addressed. Asylum in the United States is shut down. There's no hearings because of the risk of transmission. There's no hearings in the US. There's a huge backlog. If I'm not mistaken, it takes on a regular case in the US around 4 years to get a resolution on asylum petition. Under the MPP, it will take 180 days. So now people see MPP as an opportunity to get a fast track asylum, where it's not happening because it's still the rate is very low. It's below 1% of acceptance. Under the pandemic, if we see it from the angle of the United States, they have some reason in not wanting to have more people in detention. Okay, they would think, I don't want these people. But they come from the view that the migrant per se is transmitting COVID. It's a bearer of that. And that's it. That is an image. I think regardless of MPP, is the person, the migrant by himself, is not a criminal and is not a bearer of COVID. And that is the issue. Now, what is happening in reality? There's no hearing, and people are staying in Mexico. Now, the sadness of the situation, and this is, I don't think any of us can measure the level of desperation of somebody to get into the United States, perhaps, or the wish to be in the United States, to be reunited with their family. So what they want to do is to wait by the border. So now we have tents at the border because people don't want to lose their number. Whereas under Mexican law, they could easily go to Mexico City, find an attorney, build their case, and go back to their family. But this is easy for us to understand. Although I have a hearing in 45 days, although I'm getting an attorney, find a job and they go back. It's easier to say. But somebody in the circumstances applying for asylum in the US might not have the level of understanding. It is a challenge. It is complex, to say the least, to be in Mexico's position with such a neighbor that attracts so many migrants, either because it offers jobs, or because as a result of immigration control policies, families have been separated, and people are returning, or simply because their workforce is aging and more migrant labor force is going to be needed. So looking forward, I'm trying to be positive on this. Instead of thinking about MPPs good or bad, we need to think, how can we find a mechanism where people could find a work visa, fly from their home country to the United States, make some money, learn technique, learn a job, learn English, go back to their country of origin, and impose their own. That's where the discussion mechanism to regulate immigration. Because if we're so concentrated in how bad it is, we're going nowhere. So, but I don't have words to explain the complexity of what we're facing. But the fact of the matter is that we have thousands of people transit in Mexico in their attempt to reach the United States. Mexico welcome if they don't ask for asylum in Mexico. But they're also transit because their wish is to go to other place that is not Mexico. They still remain in Mexico, but people don't want to remain in Mexico. Their intention is to be in the United States and transit. Huge challenge, and I didn't think I was going to talk about migration here, but I think that's one of the pending matters that we need to address in the international. So if we think about NPP and non-reform law, they're not being persecuted in Mexico. So under the current law, everything seems technically okay, but perhaps we need to think in different concepts and innovating. How can we better regulate this?
Hear from you what Mexico's priorities on the Security Council will be, in particular in the area of international law. I heard carefully that for you, international law in some way constrains political interventions, but I'd be interested to know if 2 years after you serve on the council, you feel the same way.
And that will be the last question. If you don't mind, I will send the ambassadors posting a small reception with all the guarantees of social distancing. So we don't want people to be
wonderful. Thank you very much. With the time that I have for this, one of the keys in the international law that we want to pursue, and I don't know how successful we will be. It's quite complex. Is Article 51 in the use of force. The reality is that when we read the charter, it seems that before sending a drone, you prepare your letter, you draft it, and you pass it to the Security Council. And before, during, or right after the attack or the action, all the members in the Security Council will know what happened and will address if it was legal or not, and then take the proper actions along. It doesn't work like that. The world is not like that. Sometimes the engagement in certain imminent threat for somebody might be so pressing that they're going to do it. Then the letter will be sent 1 a.m. I'll arrive in the email of somebody, and that's it, and nobody knows what happened. And it will be difficult to look at it after the time. So what Mexico tries to promote and invite the other members will invite the other members of the Security Council and the General Assembly, the Committee of the Charter, is to have more transparency, perhaps discuss better ways to have an efficient mechanism that can constrain those that want to use Article 51 for different purpose that are legitimate use of force. It's going to be complex, it's going to be challenging, but I think it's worth doing that. Because we need to protect the Charter, we need to protect international law, and of course, rules of engagement. Otherwise, it's going to be the Wild West. And with that, I really appreciate this opportunity. Thank you very much. Thank you, Ambassador. Thank you for International.
Thank you.